Will I still owe money after a foreclosure or a short sale in California? Well, let's look at foreclosure first, and we're going to look at one loan first. Most likely, because of 580D, the one action rule and the security first rule, your lender will foreclose in a non-judicial manner, and when they do, if you fit within that statute, and if you're a single-family homeowner and you moved into the property, you do, well, you should. I'd still talk to an attorney and read the statute to make sure you fit. But when they foreclose, the bank, in theory, gets that property back in full satisfaction of the loan, so they should not come after you for a deficiency. Do they? Sometimes, sure. They'll settle the loan off for pennies, and some collector will come after you, but that's where you explain to them California foreclosure law and why you didn't owe the bank money. Now, what happens after a short sale? Well, the law is similar. 580E came out in 2011 or 2013, and after a short sale, the property goes back to the bank in full satisfaction. Not in credit's different, but in full satisfaction. The issue is that the lender's approval letters sometimes don't mirror that law, and they say you still owe money, or they want you to make payments or bring cash to the table. And when we've tried to get that removed, some lenders, not all, some, I mean, we're very good at negotiating these things. We put pressure on them, and we know how to make them do extra work and set them up for negotiating in bad faith. But some lenders will still insist that, hey, we're a federally chartered loan. We're not governed by California law. We can do this. And then I discuss the pros and cons with my client and what their goals are. And do we want to keep pushing? Do we have to risk? What are we risking if we keep pushing for better results? And we have to talk about them. So in theory, in legal theory, yes. Short sale. If you accomplish that short sale, you will not owe those lenders for the money. But sometimes the lenders make you sign things to the contrary, and you better know what you're doing, and you better be well advised when that's coming up. Now, there's one other thing that I wanted to go over here, and that is fudging on your short sale package to show a hardship. That would take you out of 580E in those protections. It says so on the face. It says if there's fraud, the lender can still go after you for damages. So, some of you may not want to reveal your asset picture to the lender. It may be so different now than before that it might look fraudulent, or you just don't want to reveal it to a second in case the short sale doesn't work, because 50% of short sales fail when they're basically less than half of the real negotiated short sales close. So, when you're giving your asset picture to a lender that might be able to come after you, particularly a second, you might not want to do that. So there's a lot of things that are going on, but I would say talk to an attorney before you do a short sale in those circumstances. My name is John McConnin, UpsideDownRealEstate.com. Thank you.